Hey everyone, Dustin here from lawatyourside.com, where we provide real legal help when you really need it. And did the insurance company send you a letter denying liability for your case? Don't freak out. It happens all the time. I'm going to tell you what that means and how to work through it. So you open the letter in the mail and your heart stops because your insurance company has denied liability for your case, and you get nervous and you get scared. Oh my God, what does this mean? Does this mean I don't have a case? Not at all. Throw all those fears, all those doubts out of your mind. Workers' comp insurance denials are very, very common. It happens all the time. Cumulative trauma claims, those are injuries where you have overtime, repetitive duties over time. All the time, in fact, most of the time, they deny those kinds of cases. Sometimes on specific injuries as well, where you're walking or something happens on a specific day, you're going fine, and then something specific happens. That's what a specific injury is. Sometimes they'll deny those as well. It's very, very common, so it's not something to think that you've lost your case or there's no more case or anything like that. Workers' comp denials at some level are meaningless. They will perhaps change the direction a case goes, but at some level they are completely meaningless. What generally is going to be meaningful is when you see a state or neutral doctor and that doctor's report about your disability. That's what's going to really determine your case. Obviously it's a case-by-case scenario, it depends on the specific facts of the case, but that's what it means. So what a denial letter specifically is, it means the insurance company is saying, we don't see any liability for your case, we're denying liability. And they'll put the reasons why, and it could be one of many, many different reasons. It might be, we don't have any record of you as an employee, or you're an independent contractor, not an employee, or we have no medical evidence supporting your injury, or you got in a physical altercation and you're the one that started the altercation. So it could be a number of different things or reasons why they're denying your case. So if that happens, all that means is they're saying that they don't want to provide medical treatment to you and they don't want to provide disability benefits to you. Now, that's not the end-all be-all. So if you can't get treatments through the workers' compensation system, there are many doctors on lien that will treat you. So what these doctors do is they'll treat you for free, and they'll go at the end of the case to try to get reimbursed from the workers' compensation insurance carrier. So they'll provide treatment in the beginning to help you out. If they deem that you're unable to work, they can certify you for what's called EDD state disability. So if you're not getting benefits from workers' comp while you're out for work, generally speaking, you can apply for EDD state disability and get benefits. There are some exceptions that if you work for the city or the state of if you work for the state of California, sometimes they don't pay into EDD disability. There may be other options for you, like a short-term disability plan, a long-term disability plan, something like that. So it can affect your treatment and it can affect your benefits if they deny the case, but it doesn't mean the case is over. So what the next step would be is, depending on the facts of the case, but generally for you to go to a state or a neutral doctor. So if they've denied the case because there's no medical evidence of your injury, then you can request to go to a state or neutral doctor. That doctor will review, do a full evaluation of you, maybe request diagnostic testing like MRIs or x-rays if needed, and write a report commenting on whether you in fact had a work injury or you didn't. Now, if they deny your case because of an employment relationship, or that you never reported your injury, or that you're an independent contractor, not an employee, those kind of cases, we may need to file what's called a priority conference in order to go to the court and ask the judge to force them to accept the case. Or it may end up having to go to a trial. Not necessarily though. What generally happens is even if they give a denial in those kinds of circumstances, depending how weak or strong their denial is, they'll usually cooperate with the process of going to a state doctor, and then after the state doctor, we can eventually settle the case. So again, denials don't mean that much, but it kind of depends on facts specifically what the denial entails. If it's more of a medical evidence denial, it's usually meaningless. You just go to the state doctor, and the state doctor gives a report, and we can settle the case or get you benefits as a result of that. I've had cases where they denied the injury and the cases settle for over 6 figures. Doesn't always happen, but it does happen sometimes. So it's not something to really worry about that in those contexts. Now, I'm not saying your case will settle for over 6 figures. It's a very case-by-case specific. Depends on the doctors that you see. Depends on what's going on. A lot of different factors go in to determine a case valuation, which I'll talk about in a later video. So thank you so much for watching that video. If this video helps you, please click the like button below and subscribe to our channel. Also, if you want a free consultation or for us to help you on your workers' comp case, please give us a call at the number below, and we'll be more than happy to discuss it with you.